kick off, thank you all so much for joining us today for our webinar on data protection and AI hot topics. For those of you that don't know me, I'm Rachel Kelly. I predominantly lead on tax and finance policy areas at the BPF, but I've also got the pleasure of looking after our privacy and data protection group here at the BPF, which is chaired by Jade Kowalski on the line. I'm delighted to welcome both Jade and Rebecca Morgan from our Privacy and Data Protection Working Group, who are going to guide us through some of the hot topics in data protection and AI, and they'll introduce themselves in a bit more detail in a moment. Before they do, I just wanted to remind everyone that the BPF is currently running our open call process, which closes on the 14th of December. A handful of our committees and working groups go up for open call every year, which is a great chance to give new members an opportunity to get more involved in our policy work. So one of the reasons that we put this webinar together now was to give people a flavour of some of the hot topics and key issues that are relevant for this group, which will hopefully be helpful to anyone considering applying via the open call. And I'll pop the link in the chat for anyone that wants a bit more information on the open call or wants to apply. And just one bit of housekeeping, if people do want to ask a question as we're going through, probably best to use the Q&A function, and then people can see questions and vote for them if they're also really interested in a particular question. Jade and Rebecca are going to try their best to I suppose, answer them as we go along. But if not, if there's anything that we can't pick up in the webinar, we'll hopefully have an opportunity to come back to you afterwards. So please do still ask. But yeah, without further ado, I will hand over to Jade and Rebecca to introduce themselves and get started. Thank you.
Brilliant. Thank you very much, Rachel, for the introduction. Just to briefly introduce ourselves, my name is Jade Kowalski. I'm a partner at law firm DAC Beechcroft, and I lead the data and privacy practice here. I have been practicing in this space for many years now, right back to the time when data protection was not quite as popular as it is now. And I have the pleasure of supporting clients across multiple sectors with a heavy focus on real estate and property. Earlier this year, I was delighted to be appointed as the chair of the BPF Privacy and Data Protection Group, particularly at what is such an exciting and important time. And I look forward to working with many of you who are dialed in today. I'm also joined by Rebecca, who will introduce herself.
Hello, so my name's Rebecca Morgan. I'm a legal director also working at DAC Beechcroft, so I work alongside Jade. And similarly, my focus is data protection and data related issues, and that's been my practice area for quite some time. I started my career at the ICO, and I've been in-house and then working along Jade for the last 5 years or so.
Perfect. So our agenda for the day and our objective really, this was really exciting for us because we really wanted to put this webinar together to bring everybody up to speed with where we are in terms of hot topics in the sector now. But we also very much see this as potentially one in a series. And so if there are future topics or topics that we talk through today that people would like covered in more detail, then please do feedback via the BPF and let us know, and we can look at organising those for the future. So what will we cover? Our agenda for the day is to touch on the evolution of data protection issues in the sector. So I think we've seen a real turning point in the last few years as to how complex some of the issues have become. We're going to look at UK data protection reform and what's on the horizon there, and again, some sector-specific implications. We will look at AI and data protection and the key issues in that space. And then we will touch on what to expect next.
So to kick off, we wanted to just think about the evolution of data protection issues in the property sector. We've seen a definite shift in recent years to issues becoming much more sector specific. But I think we'll take it back to the beginning and have a look in a bit more detail at the journey and how we've arrived at where we are today. So just thinking about the sector agnostic slant that I mentioned. Historically, we've kind of been asked to support and advise clients on really what are generic issues. So things like subject access requests, employee issues, controller and processor contract clauses, etc. So things that are not specifically focused on the sector. This ties in with the sector being generally late adopters of technology and being behind the curve, really, I think it's fair to say, in comparison to other sectors which have been a little earlier to appreciate the value of data, or sectors where they're subject to other regulations and therefore historically have been more alive to data protection considerations. As I said, though, the last few years, we've definitely seen a marked change with an uptick in sector-specific advice. And that really ties into the sector taking advantage of technology that is developing and can help with sector-specific issues. So, for example, the use of biometric ID to be able to check the ID of people wanting to gain access to building sites. And Jade will touch in a bit more detail on biometric data later in the webinar. So that enhanced use of technology has inevitably opened up the sector to much more complex, interesting and focused data protection issues. So increasingly, our workload has seen much more of a sector focus rather than being sector agnostic. So if we just go back 15 years or so to 2009 and a case which some of you may well remember, it was pretty well publicised at the time. The ICO, following a journalist investigation, raided an organisation called the Consulting Association, where it was discovered that essentially there was a secret database which held information relating to approximately 3,000 individuals. And that database had a real impact on those that found themselves on it, and they were unable to work in the industry for no apparent reason, really. The data on that database stretched back to the early 90s. So when the ICO came to look at it, this was obviously pre-GDPR, and they were thinking about the previous two data protection acts, so dating from 1984 and 1998. And as a result of their investigation, they fined the director of that consulting association £5,000, which was the maximum available at that time, but is obviously a drop in the ocean compared to what would be available to the ICO if they were to look at this currently. In terms of the individuals, millions of pounds was paid out in damages. And actually, you may be thinking, why am I referencing a case that was 15 years old? It's actually back in the news currently, because questions are being raised about the involvement of trade union officials and indeed actually the Met Police and their involvement in that database. And interestingly, one of the former ICO investigators that was involved at that time was an ex-police officer, and he's made comments which suggest that the evidence seized at that time indicated police involvement just based on the language that was used in the evidence seized by the ICO. So that's just a point of interest, but just bringing it forward back to the more current advice that we are sort of giving, issues that are coming across our desk, and also issues that the ICO is interested in. We've definitely evolved to a much more focused position. And I just wanted to give a flavour of the types of issues that we have seen in recent times. So thinking about home builders, we've come across scenarios where there's been misuse of data by contractors in the supply chain. So this has involved circumstances such as where contractors are appointed to undertake snagging in relation to new builds. they obtain homeowner details and then send marketing inappropriately. So that raises issues in terms of not only data protection legislation, but also PECA, or the Privacy and Electronic Communication Regulations, which cover electronic marketing. Thinking about the corporate property space, this is one area where we've definitely seen an increase in the use of technology, footfall technology being one example. So that type of data can then obviously be used to monitor trends in occupation, etc. So that throws up some more interesting data issues. In the construction space, I mentioned already the use of biometric data for access controls to sites. And then the final thing that I wanted to talk about was data retention. So we've seen, in relation to both housing associations and estate agents in particular, there's been ICO involvement and also enforcement action from data protection regulators overseas in circumstances where those types of organisations were retaining tenant data for indefinite periods of time, and that has come to the fore when there have been data breaches and that data has been exposed. So I think what this highlights is that we're in a place now where there are genuine sector-specific questions. Obviously, there's an increased use of technology, increased use of data, and that means that the sector needs to be more aware and focused, not just on the challenges, but actually the opportunities that arise with greater use of data. So at this point, I'll hand back over to Jade.
Perfect. One of those areas where we are seeing the opportunity presented by data really crystallise is around energy consumption data. And just sort of pausing on that concept there, I do think it's important that we look at this not just through the lens of risk and compliance, but actually the opportunities and the objectives that can be achieved when using data in the right way. So as we've seen more and more focus on the drive to net zero, the use of energy consumption data has, of course, become more and more important. And there's a really crucial question here, really, which is whether energy consumption data is personal data, and therefore whether or not you are required to consider your data protection obligations. Now, if we cast our minds back some way, there was a general assumption that it wasn't. And whilst that's certainly true in the case of commercial buildings, the situation is more complex when we're looking at residential properties. Now, to answer that question, we need to go back to the fundamental definition of what is personal data, which many people on this call will be aware of is defined as any information relating to an identified or identifiable natural person. So there's two aspects of that definition that are particularly relevant here. The first is, can a person be identified? And that may turn on the number of occupants of a residential property. And then the second is, does energy consumption data relate to that individual? The answer to that question is fundamentally yes, where that information can be tied to an individual's activities. Now, if we think that through for a moment, it's possible for such data to actually give you quite a detailed insight into an individual's timetable and their movements, when they are home, when they aren't home, what they might be doing when they're at home, potentially their habits and their lifestyle, such that you can build quite a detailed picture of their activities. And the ICO specifically recognises this concept in its guidance. Now, for completeness, I just wanted to touch on EPC certificates as pertaining to residential property, which was something that the ICO did examine a number of years ago. And it found in that case that the certificate itself doesn't amount to personal data where it's processed solely by reference to a property. But again, if we tie that back to the definition, if that information is used by reference to a specific person rather than the property, then it may become their personal data. So I think this is a really interesting example of where we see actually fundamental data protection concepts like what is personal data adapt to new processing activities and also in turn new technology. There are also some recent developments around energy consumption data that are proposed or potentially would be relevant under the new UK data protection reform proposals, and we'll touch on those shortly. Now, from one sector hot topic to another, biometric data. Now, on this slide, I've set out some of the key definitions of various terms, and I won't go through them all, but the key takeaway here is that for our purposes, biometric data for the purposes of uniquely identifying a person is special category data, which means that it is subject to all of the usual data protection protections, but also some additional protections and requirements for processing under the UK GDPR and the Data Protection Act. Now, we've seen the use of biometric data, particularly facial recognition technology, or FRT, expand specifically in the context of building access and monitoring. I also think with facial recognition technology that it's worth taking a slight step back and also acknowledging the broader political and cultural considerations around the use of such technology. In the UK, I think we have a scenario where people are generally a bit uncomfortable and a bit suspicious of such technology, but that position is even starker in certain European jurisdictions. And we see that come out in the guidance from the regulators and their activities. So I thought we would look at two enforcement actions from this year. The first is in respect of Serco Leisure. Now, the facts of this matter were that Serco, in its role as employer, were processing biometric data, both via facial recognition technology and fingerprint scanning for the purposes of monitoring employee attendance. Now, in a post-COVID back-to-work environment, employee attendance monitoring has become a hot topic in itself. But you sort of throw the use of biometric technology into the mix here, and actually it becomes very complex. And this use case resulted in a complaint to the ICO, and an investigation followed. Now, Serco's case was that certain employees were body punching. So essentially colluding to fraudulently sign each other in at work and falsifying their time cards when they weren't actually on site working at all. Serco suggested that this technology was the only technology capable of eliminating this activity because quite clearly you can't swap a face or a fingerprint. Serco considered that their lawful basis in this case for the personal data element was that the processing was necessary for a contract, the employment contract, and that they could also rely on legitimate interests. And then for the special category biometric element, they asserted that they were relying on the fact that such processing was necessary to comply with employment regulations. They also suggested that they had provided employees with the ability to opt out of using this system and provided an alternative way of registering attendance. So what was the ICO's view? Well, the ICO found that the use of that technology in this instance was unlawful. They found that it was not a necessary or proportionate processing activity, given the availability of less intrusive alternatives like ID cards or fobs. They also found that employees weren't given a clear alternative to biometric scanning, and that, as we see time and time again in the employer-employee data processing scenario, there is an inherent imbalance of power, and ultimately there was a pressure to comply and to use this system. What did the ICO do in this scenario? Well, interestingly, it ordered that the organisation stop using this technology for attendance monitoring and that they destroy that data within 3 months. The ICO's focus continued with another investigation, this time in respect of a secondary school, Chelmer Valley High School. In this case, the secondary school was using facial recognition technology for the purposes of operating a cashless system in the canteen for food purchasing. It did so here on the basis of assumed consent, which, as everybody will know, isn't actually an available basis at all under the UK GDPR. But this investigation was quite interesting in that it had a slightly different focus to that of the Serco investigation. So the ICO honed in here on the process or the lack of process that Chelmer Valley had been through before they rolled out this technology. So there's some interesting and slightly different learnings from this activity than there was from the previous one. Now here the ICO issued a reprimand in line with its current policy of using reprimands in respect of public bodies and public services. But the focus here was on the fact that there had been no data protection impact assessment carried out. The school had not consulted its DPO, and the school had not engaged with parents or students before implementing this system. So their remediation activity was much more around that accountability process piece. And there we see on the slide, there are a few other examples of where there has been similar activity for similar processing purposes. So that is really a bit of scene setting, I hope, which gives you a flavour of the sector-specific issues that we're starting to see, and I think we'll continue to see. So as I said, it is an exciting and somewhat complex time for navigating these issues. To add to that, to make things ever more complicated, we have UK data protection reform on the horizon. Now, I set out the timeline on this slide in quite a lot of detail, and the reason why I have done that is because I think it gives us interesting context around the policy reasons and the politics for the proposed data protection reform. And it also gives us some insight as to where we might go from here and what happens next. So briefly stepping through this, back in May 2022, we had the proposed Data Protection and Digital Information Bill, and this was really tabled with a great deal of fanfare around, to coin the phrase, taking the Brexit dividend, moving away slightly from the EU GDPR that was seen as quite onerous, particularly for the SME population. We then had the summer of revolving prime ministers in the UK, and one of the few things that united them was data protection policy, data policy, and looking at reforming the UK landscape. So much so that actually the original bill was considered not to be ambitious enough, and it was withdrawn on that basis. We then had, in March 2023, the Data Protection and Digital Information number 2 bill, with its very snazzy title tabled. And that, despite being sort of highlighted as actually going much further, really was just a slightly further extension of the original proposals that had been tabled. Now, that bill, obviously proposed under a Conservative government with Labour in opposition, proceeded fairly far down the legislative process. So it was subject to a fair degree of scrutiny, and there were some substantial amendments made to the wording of that bill before the general election was called earlier this year. And it didn't make it through the period known as wash-up, where you have a short period of time to finalise any existing proposed legislation before the election and they all fall away. So we lost the DPDI number 2 bill at that point. But as I say, the fact that it made its way so far in the process is important for reasons that I will come on to. Taking us forward again to the summer of this year under the Labour government, in the King's speech, we had reference made to a new data reform bill. And then in October this year, we had the Data Use and Access Bill, or the DUA Bill, or as we hear it's known in the Information Commissioner's Office, the Dua Lipa Bill, put forward. That has had its second reading and it entered committee stage just yesterday. I just wanted to sort of tie that all together with a bit of forward looking and say that the reason why I reference the sort of change in government so much is because this is obviously a bill based on previous versions that has been subject to a great deal of scrutiny from both sides. And therefore, the expectation is now that it will have a fairly swift progress through the parliamentary process because of that history and because it was ultimately originally a Conservative proposal and subject to Labour scrutiny and is now following the opposite path. So what are the drivers for reform? Well, as I set out on the slide there is a real focus on using data for good, using data to support access to public services and using data for the purposes of innovation and driving the economy. I set out this because I thought it was quite a nice slide, and you can see here sort of the figures that are being highlighted as demonstrating a real tangible benefit that changes to data protection policy will bring. What might the future structure of data protection law look like? Well, if the bill does become an act as is expected, unfortunately, we will not just have that as our sole source of information to consult, but we will have this patchwork of existing laws and a new law which seek to cross-refer and amend each other, which does present a general challenge around working out the current and the correct position in relation to particular issues, because you are cross-referring to multiple pieces of legislation. So what does the DUA bill say? Well, I've set out its constituent parts on the slide here because I think they demonstrate quite nicely that although it focuses on data protection and privacy, that is just one part of what is actually a much wider and more far-reaching set of proposals. And we're going to walk through some of those, the ones that are particularly relevant for the property sector now.
So, I've put up on the slide here 5 particular areas that I want to focus on that I think are especially worthy of our consideration. Most of them are actually intended to have application across sectors, but there are particular points of relevance in this field. So the smart data framework, I think, first and foremost, is one of real interest. So it's something that I'm going to come on to speak about in a little bit more detail in a moment. But I think there's a particularly exciting opportunity here in relation to the property sector. The next item that I've put up on there is National Asset Underground Register. And the proposals under the bill essentially are to improve the efficiency of making relevant information available regarding the UK's underground assets. And again, I'll come on to that shortly. In terms of recognised legitimate interests, the proposals are not focused on any particular sector, but what they do is allow, in certain circumstances, a controller to rely on legitimate interests as its lawful basis without needing to do a legitimate interest assessment. So if you'll remember, that's the 3-stage test, and that involves balancing data subjects' rights against the legitimate interest in question. The bill proposes quite a number of recognised legitimate interests that will apply, obviously, in various different circumstances. But just one that I wanted to pull out today was in relation to the processing for the prevention and detection of crime. So that one, I think, specifically could be useful in relation to requests that might be received by building managers for requests for disclosure for CCTV footage from police. What we see from clients is that those can take a bit of time to deal with, depending on who within the same organisation is dealing with it. You might get sort of inconsistent ways of handling with them. So the idea with the recognised legitimate interest is that it would make that process much more straightforward and streamlined. So I think there are some real benefits there. Next is the digital verification services provisions. This kind of really develops on top of the existing provision that we've got. So essentially that allows individuals, as the name suggests, to verify their identity using digital mechanisms rather than sort of getting out your driving license from your wallet. So in terms of relevance to us, I think the sort of lettings sector is an obvious example where proposed tenants will need to verify their identity, so can use a DVS process to do that much more quickly. And actually, I think there's indications that those systems are much better at detecting ID fraud. And then lastly, at this point, I just wanted to mention the provisions around smart meter communication services. I think Jade and I, when we saw that headline, were quite excited and interested that there might be something of real relevance here. But actually, there isn't really anything to see here. There's no takeaways. Really, the provisions are very specific to the smart meter kind of infrastructure and are around processes to appoint a successor provider. So there's not really anything for us to note on that. So I do want to come on now to the smart data framework, because I think this is generally one of the most exciting parts of the bill, but also for the sector, I think it's particularly interesting. So I just first of all want to sort of set the background and explain what the smart data framework does. And then on the next slide, I'll bring that back to focus really on what it means for us as a sector. So essentially, the bill sets out quite a high-level framework for smart data schemes. And the idea is that the operational detail will follow under regulations issued by the Secretary of State. It does build on the existing open banking framework. And really the aim is to support the sharing of information with customers and in appropriate circumstances with other parties. Now, I think it's important to flag here that data sharing of customer data with people other than the customer actually requires the particular customer to give their authorization that they are content for data to be shared with others. So what data are we actually talking about? It's fairly broad in scope. So I wanted to mention business data first off. So that is information which is related to the supply of goods, services, and digital content, which is provided by a trader. And that can include things like the prices or terms upon which they supply those, details around the performance and quality and feedback, etc. So the more sort of general type of information. Customer data is then defined as being information that relates to a particular customer or trader, and that will include details around the price that that customer is paying and other terms regarding the supply to them of goods, services, etc., how they are used by the customer, and their performance when they're used by the customer. And I think it's quite important just to flag at this point that customer isn't limited to an individual customer. It will also include business-to-business provision. So, having sort of set the scene there, I just wanted to focus in on what that means for the sector. So as I said, the framework is intended to be sector agnostic. It's intended deliberately to be fairly broad in its range, but the focus of it seems to be actually rebalancing the asymmetry between the traders and customers, really to enable customers to be more informed about what they are purchasing, to enable them to sort of better manage the goods and services that they buy and save money, etc. I think actually there's a real missed opportunity there. That focus on benefits for customers rather than thinking about strategic gains that might be drawn from sharing large data sets in particular sectors seems to be, as I've said, a real missed opportunity. So if we think just about the environmental issues, which are very live at the moment, we know that the built environment is directly responsible for around 25% of total UK emissions. So these smart data provisions could be really helpful in the sharing of energy consumption data across commercial and residential property. We know from the BPF's own report on energy data, buildings and net zero, closing the data deficits, that actually data sharing and access to data is one of the most significant hurdles in that drive towards net zero. And actually the sharing of smart meter data with relevant organisations is one option that's been identified as being able to make a real significant change there. But the question that I've put up there on the slide, does the customer consent-based model work in this context, I think is a really interesting one, because even though generally people and businesses are much more alive to the current environmental problems, with the best will in the world, you are relying on individuals and businesses to opt in for their data to be shared. And I think that is likely to lead to patchy uptake. And what that means when you've got incomplete sort of data sets is that the value and the meaning that you can derive from those is somewhat limited. And I think the opportunity for mandated data sharing is one that we're really keen to explore. So as a BPF group, the Privacy and Data Protection Group, we've been involved in thinking about this and actually looking at engaging at the committee stage of the bill to see whether there is anything we can do there to actually facilitate that. So I'll then move on to just run through the National Underground Asset Register. So the bill essentially sets up a framework for the creation of a register of underground assets in the UK, which would cover 600 or so asset owners from both the public and the private sectors. The bill sets out obligations for those asset owners to upload relevant information into a register, which can then be accessed in appropriate circumstances. And similarly to the smart data provisions, what we've got in the bill is a high-level framework with the intention that the detail will follow in regulations later. In terms of uses of the register, the idea is that it'll be useful, for example, in the safe digging context, so that relevant information can be obtained much more quickly and in a streamlined manner before kind of breaking ground on developments. There is actually currently a sort of pilot version of this register ongoing. There has been a consultation and some feedback, and actually there have been quite a number of other use cases aside from safe digging, which have been identified in relation to, for example, electric vehicle charge point rollout, use cases in the conveyancing space and in the property development space. So this is definitely one to watch out for in terms of its implementation. Okay. Having gone through that, I think what are the more sector-specific provisions, I now just wanted to come on and talk about a number of changes which will affect people across sectors, but are relevant for everybody. So I thought it was worthwhile just flagging out some of the main ones there. So in terms of international data transfers, I think it's fair to say that everything in the bill is being considered and scrutinised through the lens of actually not wanting to jeopardise the UK's adequacy from a European perspective. But having said that, there are some changes to the current position in relation to transfers. So, for example, there is an adequacy test which the Secretary of State will apply when looking at approving third countries as adequate. That slightly diverges from the EU's approach. So the materiality test will actually require countries to maintain protections that are not materially lower than those in the UK, rather than being one of exact equivalence. So this gives a little bit more flexibility. Moving on then to the research and statistical purposes provisions. This builds on the current position, but is intended to give a little bit more flexibility. So, for example, in relation to the use of consent for processing personal data in a research context, and the provisions around that are intended to be a little bit more flexible. And the idea is obviously to enable innovation in the research space, while also recognising that we need to maintain privacy safeguards. Thinking then about automated decision making, or ADM, this is one of the bill's central reforms. So there is a relaxation of the general prohibition concerning ADM, although unsurprisingly, special category data will continue to be restricted. There's a new definition of ADM, and it will require an assessment of the level of human involvement, and really provides a baseline for any ADM that relies on profiling. And again, the idea is, it will give businesses more flexibility, but still balancing that against the rights of individuals to allow them to challenge decisions and receive meaningful explanation. Touching on subject access requests now, everybody's favourite topic. The previous proposals under the DPDI, which included making, in certain circumstances, refusing certain DSARs, the idea was that that would be made easier by sort of relaxing the manifestly unfounded provisions, but those changes actually haven't made their way into the Data Use and Access Bill. What we do have, though, is a provision which makes it explicit that the level of searches that a controller needs to undertake only need to be reasonable and proportionate. There is new provision actually, which is interesting and worth bearing in mind, around the right of data subjects to complain directly to controllers. Controllers are going to be required to put a complaints process in place, and there'll be an obligation to respond to any data subject complaints within a 30-day time period. The bill also leaves the door open for regulations to be made, which, amongst other things, might require controllers to actually proactively inform the Information Commissioner of the number of data subject complaints that it receives. So that is a little bit of a change from where we are currently in relation to data subject requests and complaint handling. Just touching now on the ICO itself. The bill provides for a change to a corporate structure so that there will be a board that is accountable with a CEO rather than just the individual commissioner. And in line with that, the organisation will change its name to the Information Commission. And then lastly, I just wanted to touch on the Privacy and Electronic Communication Regulations, or PECA, as we fondly know them. So the changes in play here are really to bring the enforcement and fines under PECA, which are currently capped at £500,000, as was obviously the case with data protection issues pre-GDPR. It's to align the two regimes so that the enforcement and fines would be consistent across both. And then there are also some changes around the use of first-party cookies and the requirements for consent in certain circumstances. So I think I will leave that there and we'll then move on to look at AI.
Brilliant, thanks, Rebecca. So hopefully that's quite a helpful overview of both some of the sector-specific implications in the current proposals and some of the more general observations. What you may also notice from that overview is that there is nothing specifically on the topic of AI, and that is quite a glaring omission. So we thought we would spend the remainder of the session looking at the current status of regulation and then how existing data protection principles might actually provide some pretty reasonable and useful guardrails. So we're not going to go into lots of detail in this session, but we set out on the slide here some of the examples of where we are starting to see AI use cases within the sector. Some of these are quite specific and sector-based. Some of them, again, are quite general, and I specifically wanted to call out the back office functions column there, because that is one of the areas where we are seeing clients derive the most value and benefit from AI systems. So looking to actually do what they already do, but do that in a way that is faster, more efficient, and potentially more cost effective. So there's obviously a global focus on approaching AI regulation and different ways of going about that. The one that has obviously had the most attention is the EU AI Act, and there was a real driver here from a European perspective to be first to the statute book, I guess, with this, in the hope that the EU AI Act will, by default, become actually the sort of reference point for other global approaches. And that very much mirrors what we saw with the GDPR, and then what we have seen since then is that actually various flavors pop up, but they are, in many instances, borrowing concepts or provisions from the GDPR. So I've set the objectives of the AI Act out on the slide here. I'm not going to go into any detail particularly, other than to highlight that the Act itself is actually currently in force, but the operative provisions are being phased in over the course of the next few years. And it regulates by reference to risk. So there are different tiers of risk and different provisions that apply, including an outright prohibition, depending on the level of risk that the relevant AI system poses. Where are we in the UK? Well, the UK position is somewhat unclear currently. Previous proposals focused very much on regulating by reference to principles, and those principles being enforced by existing regulators. Now, there was somewhat unfortunate timing with the release of this proposed approach, in that it came weeks, months, if not weeks, just before really the explosion of ChatGPT and the fact that AI suddenly became the topic on everybody's lips. So there was actually quite a bit of toing and froing with commentary around whether or not that approach was actually going to evolve in due course anyway. But then what we have seen in the King's speech this year is this particular reference that I've set out on the slide, which talks about appropriate legislation for those working to develop, and that might be a key point. So we might see something that's only focused on developers to develop the most powerful artificial intelligence modules. And so again, is there going to be a focus there on specifically looking at providers of the big general purpose AI models? We are expecting quite a narrow AI regulation bill imminently in the UK. But leaving that aside, where are we in terms of utilising the current tools in our toolbox to provide some guardrails around the use of AI? Well, my view is that existing data protection concepts do a pretty good job of that. And Rebecca's going to take us through some of that application now.
Excellent. Thanks, Jade. So as you can see from the slide here, there are quite a number of existing guardrails, if you like, that apply in the data protection space, which I think it's fair to say we can transpose over to provide controls around AI. So whether that's the the development and creation of AI systems, or whether that's the deployment of those AI systems as businesses can develop their reliance or use of AI systems. So I just want to pull out a few of the kind of key data protection concepts and flag how those might be relevant when we're thinking about the use of AI. So fairness is obviously one of the fundamental principles of data protection. And in the context of AI, I think it's one of the most interesting and knotty concepts. So really, we're asking what is fair use of data in an AI context. That might involve thinking about bias. So that might be in relation to the training data sets that are used, and also in relation, crucially, to the outputs that an AI system produces. So clearly, I think there's been quite a lot of debate around unintended but unfair outcomes for individuals and for specific cohorts of individuals, which results potentially from the data sets that the models were trained on initially. And that leads on to the question of data ethics, which is obviously a huge topic in and of itself. But the idea is that we need to think about addressing individual and societal harms that may arise from the development and the use of AI, so that we've got ethical, fair, and safe AI applications. I just want to move on then to transparency, which is obviously another key data protection guardrail, but actually something that can be quite a challenge in the AI space. I think it's been sort of well noted that sometimes the developers of AI systems themselves don't quite understand how their models are working and how they arrive at the outputs they arrive at. So in that context, you can see how, as a kind of deployer of an AI system, it will become quite tricky to explain to individuals in a meaningful way and a transparent way how their data is being used to reach outcomes based on the use of AI. I did just want to flag here that a while ago, the ICO and the Alan Turing Institute partnered up to produce some guidance around sort of explainability in relation to decisions kind of delivered or assisted by AI. So that's quite a useful piece of guidance. Lawfulness is another principle. So obviously we need to be thinking about general lawfulness and compliance with not only data protection law, but obviously other specific laws. There are a number of other legal concepts which have crept into the public awareness. So recently there's been quite a lot of press around the use of web scraped data to train AI models, and that's thrown up issues around intellectual property, the use of copyright information and contractual obligations, etc. So they're all things which are relevant. And then finally, I just wanted to draw out data subject rights, because that is obviously a fundamental cornerstone of data protection. And I think it's one that's equally, if not more important in an AI context, so that individuals are given the opportunity to challenge and to get meaningful interaction from humans in relevant circumstances. And then I just wanted to quickly talk through what we can expect next in this space. We spent quite a lot of time today talking about the bill, and Jade mentioned the committee. I think the first stage of the committee reading happened yesterday, and there are a number of dates penciled in up to the 18th of this month. I don't think we'll get this now before Christmas, but probably in the new year at some point. There is a consultation on the AI regulation bill, which is anticipated. Looking slightly further ahead to the spring, we are expecting the Commission to finalise its code of practice in relation to the EU AI Act. Looking closer to home again, but staying in the AI space, we are expecting the ICO to update in relation to its generative AI and data protection series. The consultation for those closed on, I think, the 18th of September this year. So we should expect something hopefully next year. And then just finally, the European Commission will be submitting a proposal to the Council for a decision just to formalise the EU's participation in the Convention. And the Parliament will also be called upon to provide consent. So again, we are expecting an update on that next year. So quite a lot to look out for.
Perfect. In almost perfect time, that has hopefully given you a bit of a flavour of the issues that we're seeing and why they're so relevant, hopefully enough to whet your appetite. So I'll hand back to Rachel.
Thank you very much, Jade and Rebecca. Absolutely fascinating and clearly a really busy area. And I think our Privacy and Data Protection Working Group are going to be busy discussing these topics over the coming months and years. So if this is an area that's of interest to you, a final reminder that we are running our open calls for half a dozen of our committees, closing on the 14th of December, including our Privacy and Data Protection Working Group. So if this is an area of interest to you, please do apply. But with 1 minute to go, yeah, final thank you to Jade and Rebecca. Thank you so much for your time. And thank you all very much for joining us and listening in today. If you have any follow-up questions or feedback, please do get in touch. Thank you all very much.